We want to talk to you today about the IRA Trust. Now that may not mean much to you, but it's a very important concept that you need to know a little bit more about. And what we're talking about is a trust where your IRA and all other retirement planning benefits can be paid into when you die. So a very typical situation is a beneficiary designation will be completed to name your spouse as primary beneficiary, and if she's not living, then to your IRA trust. It really is a retirement planning protection trust. It's not only for your IRA, but it's for all other retirement planning assets. Those assets you have not yet paid tax on. And the reason it's so important to name the IRA trust instead of naming your children directly is the fact that in June of 2014, our U.S. Supreme Court made a decision where they said anybody who's inheriting a retirement plan asset, and they were dealing specifically in that case with an IRA, that the creditors of the children could reach that asset even though it was still sitting at the investment company and it hadn't been paid to the children yet. And the reason they stated that was because they felt that that was not the children's retirement plan. It was the parents' retirement plan that the children were inheriting. So they made a distinction so that an inherited IRA was reachable by the creditors of the children, even though the children's own IRA is not reachable. So we had to come up with a solution to stop that problem. And the solution we came up with, we have called the IRA Trust. So very important for you to understand the need for you to have this as part of your estate planning package. Now, in talking to hundreds of clients about this, the first thing they say to me is, well, I already have a trust. And that is true. You have an estate planning trust. You have a living trust. You have a trust that we may even set up for you. And that trust is designed to avoid the probate process and to say who's going to get your money when you're dead. But it's not designed to protect your retirement plan from being reached by your beneficiaries' creditors. So that's the main reason we need this new IRA trust. Now, there's another advantage to it, and that advantage is it slows down the process of the beneficiary making a decision how rapidly they're going to take the money out of the IRA or other retirement planning asset. So, how does that work? Well, if you name the kids directly, in theory, the kid could call from your funeral to the investment company and say, I've been named the beneficiary, please send me my money. And we know if that happens, bad things happen from a tax perspective. What do we mean by that? Well, if they take it out all at once, the child will be in higher tax brackets. And we strongly encourage income tax bracket planning. What do we mean by that? Try to control the amount of income that you receive each year and make sure you receive enough of it to use up at least your 15% bracket. People don't realize that there is a 60% increase in tax if they exceed the 15% bracket, because the next bracket is 25%. That's a 60% increase over the 15% bracket. So we don't want to see your children pile $100,000, $150,000 that they may receive all in one year because they grab it all at once and they put that into their income tax return and they push themselves well beyond the 15% bracket. So again, by using the IRA trust, we can slow down that decision process, put that decision process in the hands of multiple people. How do we do that? Well, what we do is when you set up the trust, you, the parent, are the trustee. When you're dead and it goes into the IRA trust, maybe because your spouse has predeceased you, then what do? Well, we do let the child pick his best friend to be the trustee. But at least now the trustee and the child have to talk it over as to how rapidly we should take the money out. And the trustee there has responsibilities to look at the situation and see what makes the most sense. And maybe it's just to take out the minimum required distribution, and that may continue for 5, 10, 15, 20 years, or it may be to take out multiple amounts of that minimum required distribution. Maybe because the year in which the parent died, the child is in a low income tax bracket. Maybe he has zero income. Maybe the child didn't work that year. So that's where, in coordination with hopefully a financial planner, maybe a tax return preparer, a CPA, and maybe even including myself, the attorney, to give advice to the trustee and the child as the beneficiary as to how they should plan to take the money out. And we're hoping that it's going to be done in the optimum manner, the best manner from a tax perspective. Then we set that aside and we go over to the other side of the question, which is, oh my goodness, when I died, my son was in the middle of bankruptcy. We certainly don't want him to take all that money and put it into his bankruptcy court. So there, the trust may just hold on to the money, accumulate it, maybe even pay the tax on it. So we have lots of options built in. So now the question to you is, does this make sense to you? Is this something you need to do? And from my experience in working with my clients and answering their questions, many of them will say, oh, this bankruptcy thing, I'm not concerned with that. My kids pay their bills on time. To which I spring up that even bad things can happen to good kids. And one of the things I'm very concerned with is the fact that the child drives a car and that the child could cause an accident and could end up with a very large judgment against the child because the child hurt somebody in the accident. And that amount that the injured party received as a judgment against your child could far exceed the child's insurance limits, even their umbrella liability insurance limits. So you do not want to take that chance that your child ends up with a large judgment against your child because of an auto accident. Because when that happens, that entire amount sitting in your IRA that they are now inheriting, or your retirement plan that they're now inheriting, could be lost to their judgment creditor. So think about it. That's not a risk you should take. And it's very simple to call our office and set up a phone call or an in-office appointment for free where we could look at your situation and see if this makes sense for you to do this planning. We have many clients who, when we discuss it with them, go, you're right, I shouldn't take the risk. Even though I trust my kids and they don't have creditor problems, why should I take the risk that maybe over the next 10, 20, 30 years of them pulling money out of my retirement plan, that all of a sudden they have a judgment entered against them, or worse yet, they're in bankruptcy court and they lose that money. So if you don't want to do it for the tax reasons, do it for the bankruptcy reasons. And if you don't want to do it for the bankruptcy reasons, do it for the tax reasons. We generally estimate that a child, by doing good income tax bracket planning, by taking money out slowly from your retirement plan after your death, that the child will be able to save at least 10% of the value of your IRA at death. Hopefully this message has been important to you and well worth your time of listening to it. You can always get a hold of our office by calling us at 262-634-6659. Thank you for listening.